Hey guys, Pankaj Raval, founder of Carbon Law Group, and I'm back again today talking about operating agreements. Now, if you have an LLC, this is going to be really important for you to listen to. Let's get into it. Now, operating agreements are the foundational document of any LLC. When you have an LLC, you're going to definitely want to have an operating agreement. They work for single member LLCs, and they also are important, probably more so for multi-member LLCs. Operating agreements have around 6 main parts to them, okay? And they can be short, they can be 5 pages, they can be 80 pages, all right? They're going to really determine how LLCs will function, how management works, how voting works, how shares are distributed, how many classes of units you may have, as well as what happens in a liquidation or what happens in a dissolution, what happens if someone wants to withdraw, what happens when we have disputes. So operating agreements talk about all these important areas of governing an LLC and are critical for you to really understand and draft well. We're going to talk about 6 main areas today just to keep it concise, but there are many other areas that you can address in an operating agreement, and really there's no limit on what you can include. You can include roles of the parties, you can include expectations, you can include buy-sell provisions. Now, buy-sell is also a separate agreement that you could have as well, but oftentimes people also have buy-sell provisions in an operating agreement where they can dictate what happens in the event someone needs to leave or someone is maybe acting in a way they are no longer be part of the LLC. These are all really important decisions to consider when drafting your operating agreement and also reviewing one. So the first area I want to talk about is ownership and membership. It's really important to understand that a operating agreement or an LLC is comprised of members, and that is compared to a corporation that is comprised of shareholders. This is a very important delineation, and oftentimes I see it mixed up a lot in documents and emails, and when people are even calling us, they're saying, oh, I want a partnership agreement or I want bylaws. But no, when you're talking about LLCs, remember, you were talking about operating agreements and you were talking about members of the LLC. You can also have managers of an LLC, but the members are the ones that generally own the LLC. Now, when you're talking about the ownership, you generally can have ownership in the form of a percentage or in the form of units. Units are not seen quite as often, but are actually very important because they often function like shares in a company. Units are great because you can issue more units, you can take away units. When you talk about percentages, the downside is that you are often stuck with 100%. If you have issued 100% out to all the founders or all the members of the LLC, and now you want to bring in someone else, you have to now get membership interest from some other member and transfer it to that new member. Alternatively, if you have units, you could potentially still have the LLC issue additional units from the company, and now everyone else is equally diluted. There are nuances there in how you want to structure it, but very important to understand in terms of how you set up a company, especially if you're raising funds. You really want to think about units as opposed to membership interests. The next thing you want to consider is management. It's really important to understand who is going to be managing this LLC. In California, for example, you can have member managed LLCs, you can have manager managed LLCs, you can have managed by more than one member. There's a few different ways you can manage an LLC, but it's really important to understand, okay, are you going to have a manager managed LLC or a member managed LLC? There's nuances here that relate to securities laws. For example, if you are having a manager managed LLC and there's certain passive members, then you may have to actually file securities exemptions, because if you have passive members who have put in money and are expecting profit from the LLC, now technically those membership units are actually securities because they meet the definition of security, and now you may have to file exemptions. So how you structure it is actually important in terms of the other legal nuances that could come up in terms of securities laws and other legal issues. So think about who's going to be managing this LLC. Is it going to be the managers or the members? And think about, okay, what are the ramifications of making such a decision? The next thing you want to discuss is contributions. All right, this is really important. How are you going to be capitalized? Every business needs to have money to function. Okay, I don't care what kind of business you are, you're going to have capital. And the question is, okay, how are those contributions going to be treated? Are you guys all going to put in a certain amount originally, but then maybe someone puts in more later on as a loan? Are some of those contributions going to be paid back first versus just getting a share of the profits? You can also decide on divvying up profits in an LLC. You can say, okay, hey, we're all putting in the same amount, but I want more of the losses this year because I have other investments I want to offset. So it could be a tax planning strategy as well, where someone actually wants more of the losses to take on their personal taxes. So these are all things to consider when you think about contributions in LLC. What are people putting in money-wise, but also what are people putting in sweat equity-wise? What are people contributing? What value are you each bringing to the LLC? A really tough question, very important question, very important to really sit down and think about. What is everyone bringing to this LLC? LLC? What is everyone bringing to the venture, and how is everyone going to contribute? Next, you want to think about dissolution and termination. What happens if things don't work out? What's the vote required to dissolve it? What happens if we terminate? Who is going to be in charge of winding things up? These are important things to consider, that not all ventures work out, and it's good to have an exit plan in case it doesn't. Next, we want to talk about amendment and modification. How do you amend the terms? Is it going to require everyone's approval? Is it going to require just the manager's approval? How many people are involved? And is it going to get more complicated to amend this? You want to really think about, okay, how are we going to adjust this document in the future? Does it require everyone's consent? Because unanimous consent could be very difficult, and especially if you have too many cooks in the kitchen. But then again, you don't want someone to feel like their rights are being trampled on. So you have to be really careful about how you amend these documents, because if you violate someone's rights, you could have a minority interest action brought against the company. So think about how are you making these amendments, what's required for an amendment, and how are you going to document those amendments. And lastly, you want to think about, okay, what if there's a dispute? What happens in those situations? Do we have mediation? Do we have arbitration? Do we go to trial? Disputes happen, but you want to think about, okay, what's the best mechanism for us to resolve these disputes? Sometimes you have an advisor come in and help break that tie, especially when you have even number of members. Tie breakers, whether you have 2 members or 4 members, if you have ties, you want to have someone who can help break that tie. Ideally, someone you guys all trust, but it's really important to figure out how to break these deadlocks, because deadlocks can be very challenging for all businesses. It puts things to a halt, and now you can't do what you set out to do because you guys are at an impasse. So think about, how are we going to make those decisions? How are we going to resolve these disputes in a efficient manner? Is there someone else you guys can bring in that you guys trust can that be that tiebreaker? Really important as you guys build this business. So we talked about ownership and membership. We talked about management decision making. We talked about contributions and distributions. We talked about dissolutions, and then we also talked about terminations and disputes. So these are the things that you really want to think about high level when you think about creating your operating agreement or reviewing it. These are just some of the topics that come up. Again, like I said, there could be 5-page operating agreements, or it could be 80-page operating agreements, and there's a lot more that goes in. There's a lot of tax issues that could be addressed in an operating agreement. Also, you can elect how to tax the LLC. You could elect to be taxed as a corporation or an S corporation. That also will change things in terms of how the LLC is governed. What you've got to know is that there are laws. Generally, many states have adopted the Uniform Limited Liability Company Act, but if your state has not, then you want to think about, okay, what are the laws that apply to these LLCs? What rights and duties can be waived? Are there fiduciary duties involved? Are the managers and members where you have to treat each other with a certain duty of loyalty or duty of care? Think about all those duties. Think about what the state law says, and also how you want this document to function in terms of making sure that you can avoid disputes, making sure that the company operates effectively and efficiently in the future as you build this business. I am Pankaj Raval, founder of Carbon Law Group. Hope this was helpful. We can't wait to help you if you need anything. Thank you.